What constitutes fraudulent asset transfer? Have you ever wondered what makes an asset transfer fraudulent? This is an important topic, especially in the context of elder law and Medicaid planning. Let's break it down in a way that's easy to understand. A fraudulent asset transfer, also known as a fraudulent conveyance, happens when someone moves their assets with the intention to deceive creditors or avoid paying debts. This type of transfer is not lawful and can be challenged in court. At the heart of a fraudulent transfer are a few key elements. First, there is the intent to defraud. This means the person transferring the asset is doing so knowingly to escape their financial obligations. Sometimes this intent is clear, while other times it can be inferred from the situation surrounding the transfer. Next, we have the issue of fair consideration. If someone gives away an asset or sells it for much less than it is worth, that raises a red flag. For example, if a house worth $100,000 is sold for $10,000, that could indicate a fraudulent transfer. Another important factor is the financial status of the person transferring the asset. If they are insolvent or become insolvent after the transfer, it suggests that they are trying to hide assets from creditors. Timing also plays a role. Transfers made just before filing for bankruptcy or when legal claims are looming are often scrutinized. Courts look for patterns that suggest the transfer was made to shield assets improperly. There are also certain indicators, known as badges of fraud. These include transferring assets to family members, secrecy surrounding the transfer, or sudden changes in ownership. These signs can lead courts to suspect fraud. In the realm of elder law, fraudulent transfers can take specific forms. For instance, elderly individuals may transfer assets to family members or trusts to qualify for Medicaid benefits. If these transfers are done with the intent to deceive Medicaid or creditors, they can be considered fraudulent. Medicaid has a look-back period, typically 5 years, during which they review asset transfers to prevent improper qualification. Another concern is undue influence. If an elderly person is pressured into transferring assets or changing their will, that transfer can be challenged. This is especially true if the person is incapacitated or vulnerable. Beneficiaries or creditors who suspect fraudulent transfers can take action. They can petition courts to recover assets that were wrongfully transferred. This is common in disputes involving wills, trusts, and estates. In practical terms, it is essential for individuals to seek advice on lawful Medicaid asset protection strategies. This helps ensure that they comply with legal requirements and avoid fraudulent transfers. It is also wise to review asset transfers for signs of fraud, especially when vulnerable individuals are involved. Understanding what constitutes a fraudulent asset transfer is vital for protecting the interests of creditors, heirs, and public benefit programs like Medicaid. By being aware of these factors, individuals can make informed decisions about asset transfers and avoid potential legal issues.